Well, hello. I am trying to get us going on Facebook Live. For some reason, it keeps timing out. So we are going to go in. I'm going to um, let my speaker in. He got stuck in a different file here. Don't see him. Well, Jeff, I don't see you. Anyway, this is Jim Morgan. We're Life's Co-Pilot. We're going to be getting Jeff Stinson on here as soon as I can find him, but I'm not finding him in the. Maybe it's Samantha has logged in. Yeah, so hang on, I'll do that. Okay, so there we go. This should bring him in. Okay, there we go. So that's Samantha, but I think that Jeff will probably be on there. Hey, there he is. Don't you love technology?
I'm here. Yeah, I never got a link, so we went another direction, and
Yeah, well, we get you
here I
taken
am.
care of now. So, and I don't know if we're live on Facebook or not. It keeps kicking me off, so we'll see what's going on there. But we have a video before it's over with. But anyway, so welcome. Look at you out your new windows there. That's a whole new look. So anyway,
Yeah.
well, I want to have you introduce yourself. This is Jeff Stinson. He's an elder law attorney and has all kinds of alphabets behind all that as well. And he's going to be talking to us about trust tonight. So I want to let you introduce yourself and go from there here. So
Okay. Yeah, I'm Jeff Stinson. I am a certified elder law attorney, which means I've been certified as a specialist by the National Elder Law Foundation. My firm works with mostly folks who are concerned about long-term care and how are they going to meet the cost of long-term care, whether that's through a crisis or through folks who are just planning for what happens when I need long-term care in the future. So we work a lot with Medicaid and VA pension in particular, programs that help offset the cost of long-term care, help pay for the cost of long-term care. And we work within those programs rules to help folks qualify for the programs without being completely impoverished. With that, we do a lot of estate planning to work towards that future need for care and protecting assets, which is probably quite a bit about what we'll talk about this evening with Do I Need a Trust?
well, I'm really glad about this, and full disclosure, we're working with you on some of those projects right now. So, but anyway, the and we have in the past as well. So I know enough to be dangerous, but I always tell people I know who to tell to call, to get the information. So tell us about trust. Why do we need trust? What are they? What kind of options are they? All these above. I don't know if you need to use a slide presentation or whatever. You're perfectly. You've got the share thing on the bottom. Go after it if you like it.
All right. Yeah, I put together a little presentation as well as I got some visual aids too. So let me get this started here. All right, so we should be seeing, do I need a trust? If I'm successful, we should be seeing a slide
I see
there.
it. I see it just fine.
All right, so I'm just going to dive right in and I'll tell you, let me get through some of this introductory stuff here. That's me and kind of a list of things that we do here, but let me just kind of jump into this question. This is probably, if it's not in my top 5 most commonly asked questions by clients, it's in the top 10. And that is, do I need a trust? Or maybe it's half brother, I need a trust, right? And I always kind of flip that around. When somebody says, Jeff, do I need a trust? My initial answer is, I really don't know. Because we really want to know, when you're asking me, do I need a trust? What I need to know from you, what are you trying to accomplish with a trust? Why do you think you need a trust? And we're going to kind of go over a few things like, what is a trust? And then we'll talk about different types of trust or different purposes, different uses of trust. So just starting from the very beginning, if I got a little plastic container here, we can say this represents a trust. And from the anatomy of trust, we have what I call a grantor. You also might hear as called a settlor or a trustor. Basically, that's the person that creates our container here. And they're going to write a list of instructions to a trustee who's in charge of what's in the container, how to use what's in the container, and for whom they're going to use it. And that happens to be the beneficiary. So we basically start with creating this container with the grantor creating it, trustee in charge of it, beneficiary uses what's in it. So along with that, as I mentioned, the grantor is going to create this container. Then they're going to create a list of instructions. It's called the trust document. That is the grantor telling the trustee, here's how you're going to use what's in this box for the person I have set out as beneficiary. And really, it's the purpose of that document that dictates what the trust does. So a trust will vary depending upon the grantor's instructions. So it might be pay Jim $5,000 a month for life, or it might be invest all this money and you decide when you want to pay Jim, if anything, out of this trust. It also varies on beneficiary. Who is the beneficiary? It can be the creator. The grantor can be beneficiary, or it can be another child. It can be another individual. It could even be a charity. And then finally, who's the trustee? Everything's going to vary based upon who the trustee is. If a bank's a trustee, there's going to be different instructions than if it's an individual as trustee. Now, you'll hear some terms thrown around. The revocable versus irrevocable trust, testamentary versus living or inter vivos. And then you'll also hear trademarks like loving trust and keystone trust and things like that. Basically, those are just labels placed on something. Really, when you know what is a trust and what does it do, you want to go to the instructions on what is the purpose of this thing. So I mentioned that a trust is just a container. And that's the next question I get. Well, if I'm creating this trust and I've appointed somebody to be trustee and they're the beneficiary, what goes in the container? Well, the grantor, the creator, they decide what goes in the container. They can put real estate. So house and real estate can go in that container. We got a couple pieces of real estate here. So we got a stock certificate. Stock can go in that container. What else I got here? Nope. That's a bank accounts. Bank accounts go in that container. Along with that, maybe you can see this, a little stack of cash that goes in there. So on and on. Maybe the proceeds of a life insurance policy. All those things go in that container. Really, the container can hold any type of asset. So we've kind of talked about what is a trust. A trust is just a container created by a grantor, appointing a trustee to use for the benefit of a beneficiary. That's what a trust is. Let's talk about different purposes, different uses of containers. So I'm going to use a few families here to illustrate those uses. So let's start with Jerry and Elaine. You may know these folks. Jerry and Elaine, after some years of trying to define the relationship, they finally decided they'd marry about 25 years ago. So they've raised two children, Kramer and Kristen, as well as they also raised their goddaughter Jill, who is the daughter of their friend George, who had been struggling after losing his second wife to envelope poisoning. So they've got this family here. They've got two kids. They've got their goddaughter, and they've got a modest amount of assets. They're not independently wealthy by any means. They've got a house. It's got about $105,000 in equity to it. They've got some joint bank accounts. They've both got a few IRAs. There's a brokerage account. There's some vehicles and some life insurance. So Jerry and Elaine's daughter, Kristen does a lot for them. You know, she drives them to doctor's appointments, helps straighten out their house, cooks them dinner a couple times a week. Kramer actually lives closer, but he visits them relatively infrequently. He's not estranged, but he's just not particularly close, doesn't do a lot for them. Of course, Jill lives out of state, but she still visits her godparents several times a year. So what Jerry and Elaine decide to do is, you know, we're going to go away from maybe the default division of assets when we're gone. We want to set aside 10% for our goddaughter Jill because George is still kind of struggling there. We don't expect her to get much out of him. But because Kristen's really doing a lot for us, we want to allocate 60% of what we have when we're gone to Kristen and 30% to Kramer. Problem is they're worried about how's Kramer going to take that? They are worried about, well, if he learns that Kristen's getting more than him or Jill's going to be part of this plan, they're worried he might try to overturn their desires after they die. They also are aware that, you know, the work it takes to change beneficiaries every time they want to change a beneficiary of their IRA or their life insurance or the will. So they're tired of going to every IRA company several times and saying, I've changed my mind, I want to do this. And I've changed my mind, I want to do this. And they've also heard about those horrors of probate and want to try to avoid court involvement when they pass as well. So they decide we're going to create a joint revocable trust and place all of our assets in it. So they've created one of these guys and put their assets in it. Now, I always call this type of trust an alter ego trust. Superman and Clark Kent are the very same person. The only difference is one version has the cape and one version has the glasses, but they're really the same person. A revocable trust is kind of the same thing. Jerry and Elaine create the revocable trust. They're in charge of the revocable trust, and they're the beneficiary of the revocable trust. It's kind of their alter ego. The only difference they're seeing is rather than the title of their property being Jerry and Elaine as individuals, it's the Jerry and Elaine Trust. This trust is also going to make it a little easier to administer. So now, if they want to change beneficiary on their IRAs and their life insurance, say they decide they have second thoughts about this disproportionate division, they want to change it back. They go here to change that. They no longer have to contact every single life insurance company and every single IRA custodian, every single bank. They just go right here to this document and make one change. Also, it makes it a little easier for the successor. So if Kristen is the successor trustee, Kristen doesn't have to go to several banks, doesn't have to go to and pull out a power of attorney and wait for them to review it and so on. Kristen just picks up the container. She's now got it. She's now using it for mom and dad's benefit. And all she does is tell the world that, hey, I'm now in charge of this container. The other thing that this does is, assuming it's properly funded, when they both pass away, it doesn't give Kramer an easy forum to challenge the document. And what I mean by that, if you have to go to court to clear title to your assets, well, then you have an open forum where Kramer can come in and say, hey, judge, I don't like what I'm seeing here. I'm a beneficiary too, and I should have more than 30%. Has a little privacy because we're not going to court. And the last thing this guy does is avoiding probate. Now, I'm going to talk a little bit about how it's really not that horrible to go through probate, but in general, probate does make things a little easier. You don't have to get a court involved. You don't have to pay an attorney to file things with the court, update the court, get the judge's approval on transactions. It does make it a little easier. Now, I'm going to pause just for a minute because there are other ways to avoid probate without a trust. So sometimes people will say, well, I need a trust. My neighbor has a trust. My friend has a trust. And why won't I have a trust? Well, if your plan's simple enough, maybe you just have a bank account and a house. You may not need a trust. That may be overkill. We can avoid probate other ways. For example, any property that's in joint name does not go through probate. or any property that has a beneficiary designation. So we can take your house, put the kids as beneficiary on the house, done. It doesn't go through probate. So there's other ways to avoid probate than just a trust. Now, I will pause for a minute, and I don't want everyone to take from this presentation, oh, I should put my name, kids' names on everything, because making joint property joint with kids is not always a good thing. If you make your house joint, you've created a transfer, which could create a problem for public benefits eligibility. If you put your kids as joint on your house, then unanticipated things that happen in her life could affect the ownership of your house, like if they have debt problems or they go through a divorce. So don't take, Jeff said, I can avoid probate. I don't have to get a trust. I can just put everything in joint name. No, there are some pros and cons. You need to get legal counsel to talk you through it. The last thing, though, I want to mention is probate really, I think, gets a bad rap sometimes. Back years and years and decades ago, one of the things that really, I think, allowed people to say, I really want to trust, I want to avoid probate, is probate fees by attorneys were a percentage of the net worth. And I will tell you, I put as much work into a probate estate that has 150,000 as it does 950,000. It's kind of unconscionable to say, well, just because you had a little bit more, I'm going to charge you more. That's not what creates higher fees. And so since that kind of archaic percentage fee basis went away, there's not a lot of extra expense to probate administration. So I do think probate avoidance gets oversold sometimes. And there are advantages to probate. Probate can flush out creditors. Creditors have 9 months if there is no probate from the date of death, but we can shorten that period of time by opening an estate and going through probate. So probate is not always that bad. For most people, yeah, they probably want to avoid it, but it's not always that bad. All right. Get back to my trusts. So here's another family, another situation. This is the Cunningham family. Probably know them as well, Howard and Marion and Joni and Chachi. So the Cunninghams are worth a little bit more. They've got a house, again, about 105,000, some joint bank accounts, joint brokerage account, car, and life insurance. But their biggest asset is a family-owned business. Howard has a hardware store he has ran for years. And that happens to be their largest asset. If you take that out of their net worth, they're only worth about 385,000 or so. Now, the problem is Howard owns this, but Howard and Marion's daughter, Joni, and her son and their son-in-law, Chachi, has run that hardware store since Howard's retirement. In fact, it is Joni and Chachi's sole source of income. Well, Howard and Marion are concerned if they need long-term care, which could be up to $100,000 a year per person, they worry what's going to happen to that business, and in particular, what's going to happen to Joni and Chachi's way of life if they need long-term care. They don't want to sell the property. They want to make sure that, Joni in her 40s isn't we're looking for a new job just because Howard needs nursing home care. So what Howard and Marion do, they prepare what I call an irrevocable family trust. And what it does is it protects the assets that go within the container from the cost of long-term care. And what I mean by that is if Howard and Marion places the hardware store in the trust, then it's no longer available for public benefits purposes. So the principal, that hardware store, doesn't count. And Howard and Marion aren't the principal beneficiary. So that's the trade-off. They don't necessarily control the hardware store anymore. The trustee of the trust does, for the benefit of Joni. Now, in certain circumstances, they can reserve the income of that irrevocable trust. If they say, you know what, we rely on our portion of the hardware store income, they could reserve the income. Now, that's not always good from a public benefits perspective, but that is one piece of control they can reserve. We can also design that trust so that Howard and Marion still gets some favorable tax treatment. So they still get a step up in basis. And for those that don't know what that means, if Jim gives me a stock that's worth $100 and he paid $10 for it, if I go to sell that stock, I'm going to pay capital gains tax on a $90 gain. But if Jim holds that property and he gives it to me as an inheritance when he passes away, I get $100 basis in the property. It steps up to whatever it was the date of death. And then when I sell it, I don't have to pay capital gains. Well, that's something we can preserve through this trust. The hardware store probably has some un, uh, unrecognized gain. And so we want to make sure that Joni Chachi don't have to pay capital gains tax later on down the road. Other things like if a home went into this trust, we can preserve the home exclusion from gain. And in many times, we'll want to make it still grantor trust treatment so that the income tax rate is taxed at Marion's and Howard's rates, which typically are lower. I say lower, they're not as compressed. So it takes a long, long time for Howard and Marion to get into a top tax bracket where the trust, it does not. And of course, the family members can always use what's in the trust for family purposes. So Howard and Marion aren't a beneficiary, but if Joni and Chachi decide, boy, they really need something, they can make a distribution to Joni and she can spend money on mom and dad if she wants to. So that's another type of trust. Irrevocable family trusts are often used when folks are concerned about protecting assets. And it doesn't have to be a hardware store. It could be, it's real important for me to make sure my kids have an inheritance. So I'm going to put my $300,000 brokerage account in there, or I'm going to put the family farm in there. There's lots and lots of things that can go into these trusts. And again, the purpose is to protect those assets from long-term care costs. All right. Briefly, I'm going to talk about another trust. So here's another family, the Banks family. This is Phil, Vivian, Hillary, Ashley, and Carlton with their nephew, Will. Fresh Prince of Bel-Air, if you're not familiar with that TV show. So they're worth quite a bit more. Phil and Vivian have a net worth of about $25 million, and they're worried about how the federal estate tax will affect their inheritance for their kids. Now, the current estate tax exemption is $13.61 million or $27.22 million. So they were 25. So if they, as of today, they probably don't have to worry about the federal estate tax, but they're worried about, if Congress changes the rules, how's that going to affect them? So one thing that they can create is what's called a credit shelter or AB trust. These are very rare. Just because the exemption is so high, very, very few people need this type of planning anymore. But I still hear it a lot come through my office, and that's why I wanted to address it. So how this works is, Phil and Vivian each create one of these containers. They split the marital assets up between the two containers. This allows them to ensure that the first spouse has the opportunity to lock in the credit, that 13 plus and change million plus and change of exemption that the first spouse has, so that when the second spouse dies, they have ensured that they use the first spouse's credit and they'll also get to use the second spouse's credit. Again, I would opine there's probably nobody on this, and probably very few that will watch it later, that this is a concern, but I like to talk about it because I see a lot of these still come through my office and most people don't need them. All right. Here's another family. This is the Brady family. So they're a close blended family. And what they want to do is ensure that Mike wants to ensure that his assets are able to be used for his spouse, but he wants his assets to go to his kids when his spouse passes away. And likewise, Carol wants to make sure Mike gets the benefit of her assets during his lifetime, but wants to make sure her assets go to her kids at his death. And so with that, one of the things that we can do is create what's a spousal trust. It basically says, Mike says, I'm leaving my assets in trust to use for the life of Carol, remainder to my children. Similarly, Carol can do the same thing. I'm leaving my assets in trust for life to be used for Mike, and then when he's gone, to be divided amongst my kids. Another advantage of these types of trusts is typically they are drafted in a way that they are also exempt under the Medicaid program. So let's just say Mike has passed. He left all his assets in a testamentary trust for Carol's benefit. Carol's in poor health. She's run out of funds. She applies for Medicaid. Medicaid gives her 30 hours a week in home care. But at the same time, she has all the money that Mike has left her that doesn't count. And so her trustee has those funds to use for Carol's benefit in addition to what Medicaid is providing for home care. So she gets 30 hours from Medicaid. The trust can purchase some additional hours to help keep her at home. And then, of course, when she's gone, everything is split amongst Mike's kids as he wanted. So another type of trust. So we've talked about a revocable trust. We've talked about irrevocable family trust. We've talked about a spousal trust. Now let's talk about some trust for family members, because that's another place where we will use trust. They're a good tool to protect family members. So here's Ross and Rachel Geller. After being friends for 10 seasons, they sparked a romance that led to marriage, and they now have 2 children. Michael, who is 45, lives out of state, has 3 children, and Michelle, who's 38 and single. Of course, their concern is Michelle. Michelle's, like I said, she's 38, but you know what? She spends most of her time living with her parents off and on as she's between jobs. Ross and Rachel have bailed her out multiple times from credit card debt when that becomes crippling to her finances. And really, every time they feel like they've got her above water financially, she goes out and accumulates a bunch more debt on clothing purchases, extravagant vacations, leases on luxury cars, kind of lives high on the hog there. Michelle has no savings, so Ross and Rachel worry about, what's her financial security going to look like when they're both gone. They plan to leave her at least $900,000, but they worry about her wasting her inheritance within a few months. They know if they give her $900,000, she'll spend $1 million. So what they decide to do, because she's financially unstable and have no savings, they create a trust for Michelle's benefit. We often call these types of trust a spendthrift trust. And what it is, they're basically creating a container, putting a third party in charge, and then putting Michelle's inheritance within the container. So in their instance, they're instructing the trustee, you know what, pay Michelle $500 a month for life. However, she needs any more than that, anything in addition to that $500 she's getting a month, it's up to you when and if, trustee, you're going to give her the money. This way, the trustee can kind of step into the shoes of Ross and Rachel. So if there is that crippling debt situation and the trustee says, yes, this is what Ross and Rachel would do, they can pay those debts, but the trustee doesn't have to. So what it does is it stretches out Michelle's inheritance for a longer period of time. Let's shift gears to Michael. Michael's financially stable, so we're not really concerned about him just blowing his inheritance, but he and his wife's been having marital issues over the last couple of years. Their biggest point of contention they have a problem beef with his wife too, because his wife's always trying to put them in a home. She's always trying to convince Michael and Michelle, you need to put Ross and Rachel in a nursing home. They don't like that. They don't need a nursing home. So, their relationship's always kind of been one of mild tolerance when they describe Michael's wife, but it's really gotten bad. And worse yet, they're concerned that once Michael gets an inheritance from him, she may take off the next day and take half of her inheritance with him. So another solution here when someone has marital issues is similar to this spendthrift trust situation. So what Ross and Rachel did is they said, well, we're going to put Michael's $900,000 in the trust, and we'll let Michael take up to $25,000 a year out of that trust. But if he wants more than that, he needs his sister Michelle's consent to do so. And because a third party is put in charge of his receipt of some of the inheritance, if he goes through a divorce, it creates a barrier to most of his assets in the trust from being subject to the marital property division. All right, let's go a little further. So another type of trust here. So we're looking at Michael's kids. What Ross and Rachel don't want is for Cameron, who's 10, Isabel, who's 7, and Fred, who's 2, to receive an inheritance when they're under the age of 18. So while there's no reason to really suspect that any of the kids will have issues in adulthood, they're young. They don't know. They also know what Michael was like at 18 and 21, because they have another option to say, well, we'll just give those funds to someone to hold until they're 21. But then they're kind of still concerned about that age. So with the prospect of Michael dying and each one of these grandkids getting 300,000, they want to make sure the inheritance a grandchild receives goes towards education before any other expenses. Of course, they're also concerned about that ne'er-do-well daughter-in-law also kind of influencing the use of these funds for the kids. So they decide to create what I call a minor's trust. And that is simply the trustee, basically the inheritance goes for the kids. Each kid has a separate account usually. And the trustee has instructions to say, you hold these funds until a kid turns 21. And when that kid turns 21, they get a third of their property. And at 25, they get a second third, and they get everything at 28. And until then, anything other than those mandatory distributions, the trustee decides with complete discretion how to use those funds. So the trustee says, well, Grandma and Grandpa really wants this to be used for education. So 18, we'll start helping with education. Then once education's over, we'll start divvying this out in thirds. So one last illustration I have here to kind of illustrate the use of different types of trust is something we call the special needs trust. So here's Chandler and Monica, who were friends for many seasons before the romance started. They were later married. They have one son, John. John is disabled and receives needs-based public benefits. He receives SSI and Medicaid, a Medicaid waiver, actually. 5 years ago, they recognized they weren't getting any younger, and they decided to do some planning. So among other things, they arranged for John to move to an apartment in a community that supports disabled individuals out of their home. But they also created a mechanism to hold John's inheritance, because what they didn't want is for John to receive an inheritance and he lose his public benefits. So they create this container called a special needs trust that says, trustee, here's John's inheritance. We want you to use it for John as you see fit, but in particular in a way that doesn't interfere with his public benefits. Now, it's not a complete restriction, because the trustee can say, you know what, Medicaid will buy this, but it's really not all that great. We're going to buy something better out of the trust. But in general, the trustee is going to pay for things Medicaid does not pay for. And the reason why is this type of trust is exempt under Medicaid and SSI. So it allows him to keep his benefits and his inheritance at the same time. It's also a way to avoid the situation that I hear often, and that is, well, you know what? John has an older sibling. I'm just going to leave all of our assets to the older sibling, and then that sibling will take care of John. Here's the problem with that. We never know what might happen with that older sibling. They might get a divorce, and then half of John's inheritance that he's holding goes away. Or that sibling might fall in hard times and have debt issues, and suddenly that money's gone to satisfy judgments, liens, and so on. That sibling might pass away, and then those funds go to their beneficiaries under their estate plan, and they're not held there for John anymore. And finally, John might become disabled himself, and he needs public benefits. So this trust is a much better substitute than an older sibling holding on to inheritance for a younger sibling. So that was a very quick and dirty kind of illustration of the different types, that's called types of trust, which were all based on a different purpose. As you can see, they all started out with a container. They all set it out with a list of instructions. They all started out with a grantor, a creator, a trustee, and a beneficiary. The distinction there was the instructions to the trustee, who the trustee and who the beneficiary was, made the purpose of those trusts different in every situation. So next time you think I need a trust, you can kind of review through here and say, do I need a trust? Am I trying to accomplish one of these types of purposes? And keep in mind, there are other purposes. These are just kind of the most common things that I encounter in my practice. Jim, I can turn it over to any questions.
Yeah, I've got some questions. One thing is, like, you've got the revocable trust, you've got the irrevocable trust, and they have the differences as who's in control of them. Is that correct?
Well, and it's also who's the beneficiary. So one confusion that comes around the irrevocable trust is I in Medicaid rules say if I create a trust and I put my own assets in the trust and I hold any interest back, it doesn't matter whether it's irrevocable or revocable, it still counts as an asset. So to accomplish that asset preservation issue, I have to basically earmark what I put in the trust for someone else. It has to be, rather than for when I put my bank account in there, it's no longer mine. It's Jim Morgan's bank account because he's the beneficiary. And then if I need something, I can't make Jim give me any money back. I'm hoping, well, maybe Jim will see me on hard times and say, you know what, you give me this money, so I'll help you out for a while here. But I'm basically giving up all rights to that property. Now, there are some exceptions like a house. We can put real estate in there and still say, I get to use my real estate for the rest of my life. Then it belongs to Jim. But in general, that's the big distinction there if you want to make it work for public benefits and asset protection purposes. Excuse me.
So when you're picking your trustee, that's obviously a very important thing to be doing. So
Always important. Yes.
how do you go about recommending that?
Yeah. Well, everyone's always, you've got many options. Probably the most common pick is a family member. And there we want to make sure this is someone who, yeah, is trusted, but also is someone who is financially savvy. They don't have to be financial advisor level or CPA level or banker level, but they need to know enough about finances and need to be successful in their own finances to handle this. Similarly, it could be a friend with those same characteristics. Sometimes there aren't family and friends, and then we have to look outside of individuals. And in that case, if the assets are big enough, there are institutions, banks will serve as trustee. And there are also a few professionals, particularly in the Indianapolis area. That's what they do. They are professional fiduciaries. They serve as trustee for folks. And why they charge a fee, generally their fees are a little bit less than an institution.
We have a question here from Larry. Larry asks, what is a Miller's Trust and how does it work in a special needs situation?
All right. Thank you, Larry. This is probably one of the up in there, the top 10 questions I get too. So a Miller Trust. This guy got lots and lots of media attention back about 10 years ago. And that's because give you a little history here. When Indiana started with a Medicaid program, they basically elected to say, we want to be different than most other people. We want our Medicaid, we want to make our own Medicaid rules. We don't want to follow what the model set of rules are. And so up until 2014, they had to follow certain rules under federal guidelines, but they really could make things a bit different than a lot of other states. So Indiana was what was called a 209B state. That comes from the statute. But what you need to know about that is they were like one of 5 states that wanted to do their own thing. Well, in 2014, Indiana said, you know what, we're tired of that. We want to come in line with what a majority of other states are doing, and we're going to use this model system. And when they adopted this model system, they now had to start a requirement to put an income cap on certain types of Medicaid services. So specifically, if I am in an institution, I'm in a nursing facility, or I'm seeking an alternative to nursing home, whether that's home care, assisted living, adult daycare, and I have monthly income in excess of $2,829, I don't qualify unless I create a Miller Trust, also known as a qualified income trust, and put a portion of my income, at least my excess income, into that trust. So essentially what happens is any income I put in the trust, Medicaid says, oh, that's not yours anymore. And then I get below that income cap. So a Miller Trust is only used when someone has excess income or just has income they don't know what to do with on a monthly basis. And it's only going to hold monthly income. Now, from a distribution standpoint, generally it's used for medical expenses, but that trust can really be used as of right now. I say as of right now, the Medicaid agency has proposed a new rule to try to change this, but as of right now, it can be used for anything for the Medicaid recipient. You do want to be careful if you're using it for food, clothing, or shelter, or making cash distributions. But in general, it's used for anything they need. So I've had clients that um, purchased additional home care out of the trust. I've had clients that has purchased clothing. I've had clients that have purchased transportation or plane tickets to go see a family member out of state. So the Miller Trust, what I just want to leave you with is it's for income only. Miller Trusts do not protect assets.
So the other trusts you've been talking about today were asset protectors, and the Miller's Trust is an income protector.
Yeah, the irrevocable family trust that I referred to, that's the asset protection trust. Miller Trust is, where do I put my excess income so I can get over that income cap hump that's keeping me from getting benefits?
Yeah, because a lot of times, somebody might be in a situation where they've got, rent at their assisted living or their whatever that could be $6,000 a month, and they make $3,000 a month, and it means they make too much money, but they don't make enough. So yeah.
And that's exactly right. That's exactly right. And that's where this Miller Trust come from. It was to overcome that unfair result. It actually come out of a series of cases, but the landmark case back in the early 90s was a case called Ibarra versus Miller. And so the whole issue was Miller was in that situation. She had a nursing home bill that was way more than her income, and she wasn't qualifying because her income was too over their income cap. And so a savvy colleague of mine, he come up with this idea of the Miller Trust, and the Colorado Supreme Court said, yeah, we like this. And Congress said, we like this so much in 1993, they made it a statute.
Well, it made a big difference.
Absolutely. Yeah.
Because I think that's just it. I mean, it could, as dealing with these things, it's $1 here and $1 here makes the difference whether you qualify or not, which is, I guess they have to set a point, but it's still maddening if you don't have these tools.
It really is. You're absolutely right.
So what is when you're trying to make these decisions, how do you decide between an irrevocable and a revocable? What kind of criteria do you recommend that you start paying attention to?
Well, all this kind of goes back to what are we trying to accomplish here? If an individual is really just wanting to make things a little easier on administration amongst the family, they want to kind of keep things private, no, they want to avoid probate, they're probably just going to develop a revocable trust, kind of their alter ego, because that is going to resolve those issues. That'll solve those problems. But if they're trying to protect assets from long-term care, they're going to go through the irrevocable trust, because I can put all these assets in a revocable trust, but if I apply for Medicaid office says everything in here counts as an asset. But if I create an irrevocable trust where I've said these things I'm putting in trust for my family, well, then Medicaid says those don't count. So it kind of starts with, what's the purpose? What are we trying to accomplish here? Then you kind of decide where you're going to go with the terms of the trust.
Well, one thing too is I these rules seem to change every year, but I believe that to get VA aid and attendant, if you're trying to get for like offsetting costs at a in-home care or assisted living or what have you, it's a significant amount of money. And is it a 3-year look back now? Okay, and then
Yeah,
you got
right.
Medicaid's a 5-year look back. So these programs ideally would have to be set up at least 3 to 5 years before the need kicked in. Is that correct?
General rule is we can protect everything if you give us 5 years or 3 years. I'm still going to be able to protect some if I don't have 5 years and 3 years, but it's not going to be all. So a good rule of thumb is if I'm a single individual And I've waited to the day I moved into the nursing home or the day I moved into assisted living to seek out VA or Medicaid assistance. You're probably going to lose half of what you have. We'll protect half of it. We'll still put half of it in that trust, but you're probably going to lose about half of what you have. It's what I call a half and half. It's kind of the way the statute has been developed since, particularly the Medicaid statute has been developed since the mid 2000s was we want people to have some skin in the game. We'll let you keep something. You don't have to be completely destitute, but you got to use some of that on your care. So we can do stuff in crisis, but obviously, yeah, the longer we got. And so Howard and Marion, for example, they wouldn't want to wait till the day that Howard needs care because they're going to lose half the value of that, potentially half the value of that hardware store to the cost of Howard's long-term care. They want to do that years before the need so that when he needs care, we don't have to worry about this hardware store causing a problem or causing a barrier to benefits.
Yeah, I was going to say but it is so misunderstood. People still believe that they have to be absolutely destitute, that they have to spend down all of their assets before they qualify. I hear this. I mean, I hear this probably at least once a week from someone when I'm talking to people, and then or they think they have to divorce their spouse to be able to retain some of the family assets,
Right.
and that's why scope out. That's why we try to bring you guys on here to like dispel these things. And we have really good videos of you before doing this, but not such a detail on the different types of trust.
Yeah, yeah. Actually, I think this was a great idea, Jim. This is something that I think a lot of my clients will get use out of. So um, this was a great topic. But you make an excellent point. Talk to an experienced elder law attorney when it comes to these issues because there is so much misinformation going around out there that in particular, don't listen to what the Medicaid agency or the VA is telling you. 9 times out of 10, that's not going to be right. That's just what we've found.
And that's
So
also that even I mean I'm not picking on Socoa, but it goes for that because I had someone call. I said at least call Socoa. They called Socoa and they were told they had to be down to 2,000, whatever. And and we're not told there was other options that could protect some things.
yeah, yeah, right. So yes, you can always protect something. Just always know that. Tell your neighbors, tell your friends, tell your podiatrist, tell everybody you come in contact with.
It's a big deal. It's life changing for families.
Yes, it is. It is. And actually it deflates me when I see families come to me to say, yeah, dad, mom's down to her last 10,000. So we thought we'd come to you now to apply for Medicaid and get that in place. And I said, well, how has things been going? Well, we spent 400,000 over the last 3 years we could have done something with years and years ago and had a much more behind her to supplement her than just $10,000. But no one
Right.
told
So
somebody
she's
told
not
them
living.
you got to spend everything.
But that's what most people think.
Yeah, yeah. And these are all things that Congress has created the rules so that people can protect assets. Congress has created the rules so that middle class can qualify for these benefits. So it's discouraging to hear. I've been around since 1998, and I still hear the same myths today that I did 20 some odd years ago.
Well, I'll tell you what, I'm really glad you did this. We've had a really good attendance of people on here watching today. So, and I've had some people asking where they can see this. It will be, I don't know if it's on Facebook because I'm looking at my screen and it kind of tells me that something's going there, but I don't know if it is or not. But it is being recorded, and then it will be on the recording will eventually be on lifescopilot.com. You go into resources and you click down to a video library, and it'll be there probably by tomorrow. It also will be put on like Facebook on Life's Copilot Facebook page. I'll send you a copy of this as well, Jeff, so you can do with it however you want to. But those are some places you can get it. One thing I was going to ask you, maybe we need to do an upcoming one. There's a lot of things happening, changing wise in Indiana with pathways coming up this summer. So, and I am totally confused. So, I don't know if that's in your bailiwick or not, but we may need to do one.
Yeah, there's pathways. We're still seeing some rules changing coming off of the pandemic. There was some pretty favorable stuff that was put in place during this emergency session or emergency area. And now that that's over, we're seeing some of these services being peeled back that a lot of people were benefiting from. And I kind of alluded to our state Medicaid agency proposed a rule that's going to change a significant part of the Medicaid program, at least as it deals with retirement accounts and personal services, hiring my kid to care for me, use of Miller Trust that could be, I want to say devastating, but it's going to be a huge, huge change if it goes through. So I'll have lots of more news on that as well. I've helped a group of organizations put together some comments on these rules and basically trying to encourage Medicaid not to adopt them. We'll see.
Is this at a
That's
national level or is this an
no,
Indiana
this is
level?
state. This is state of Indiana.
Okay.
Yeah.
All
So
right.
we'll see. We'll see how that goes. I've made lots of points of how what they're asking to do is contrary to federal law. So we'll see what if they listen.
All right. Well, sounds very good. Well, Larry is congratulating you on doing an excellent job today,
Oh,
Jeff, which I always know you
thank you.
always do. So thank you
Appreciate
very
it.
much.
Thank you, Larry.
So and thank you for being here, Larry. And we do these twice a month. So we keep bringing in different speakers to talk about different things. So anyway, well, I am very excited. I tell you what, it's almost time for us to be done, and 3 more hours and the Boilermakers play again. So that's all good for me too. But anyways, hey, I gotta, gotta love it when you can. March always makes it less fun, but
Yeah, IU born and bred, but Purdue's fine. I know there's that whole rivalry. It's okay. If IU isn't going to be up there, let's go Purdue. Sure.
There you go. Well, I'll see you guys later. Well, thank you so much for being here and staying late tonight. I appreciate it.
My pleasure. Thanks, Jim. Thanks everyone
Thanks,
for the
Jeff.
attendance.
Thanks
Bye-bye.
everybody for being here. Bye bye.